Any mention?
Please, Your Lordship. Your Lordship, I beg to mention item number 19.
Number?
19. Your Lordship, the conducting counsel, Mr. K.C. Gautam, is unwell.
He's unwell?
He's unwell, Your Lordship. I pray that the matter comes up after 2 weeks.
No, I think he's been unwell for some time. What happened to him?
Your Lordship, he's been hospitalized.
He's hospitalized?
Yes, Your Lordship.
Okay. He's still in the hospital now also?
Yes, Your Lordship.
Yes, as the current counsel to be indisposed, this is a matter of 2 weeks, yes.
Obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 17 and 18. Your Lordship, I pray let this matter come after 1 week.
You have objection?
No objection, Your Lordship.
Okay. After 3 weeks?
1 week, Your Lordship.
Take it after 3 weeks?
Yes, Your Lordship.
Yes. Okay, after 3 weeks. What's the point of clogging the list? 1 week is. After 3 weeks. There's no urgency.
Pardon, Your Lordship?
There's no urgency in the matter.
No urgency, Your Lordship.
Fine.
Obliged, Your Lordship.
Yes.
Please, Your Lordship, I beg to mention item number 15, Your Lordship.
15?
Yes, Your Lordship. Again, consider, Your Lordship, Mr. Pubin is on sanction leave, Your Lordship. So I can you pray for 2 weeks, team?
No objection, Lordship. We were informed that counsel is...
Informing is fine, but the client has no urgency.
Lordship.
Just leave it to the lawyers to let it just meander along.
Otherwise, Lordship, we are ready. But yes, we were informed today morning that the counsel is indisposed.
Okay, 2 weeks, yes.
Much obliged, Your Lordship.
Much obliged.
Yes, Mr. Kumar.
My Lord.
Yes.
My Lord, I have to mention item number 16, my Lord. 1/6, my Lord. This matter may come after 2 weeks, my Lord.
2 weeks, okay. Yes.
Well, declare your Lordship.
May it please, Lordship. Lordship, I beg to mention item number 20.
Then there's no more matter in the hearing. Is 20?
Yes, Lordship.
Why?
Lordship, we require some more time to prepare a matter.
Prepare what? I saw Mr. General loitering in the corridor just now.
Yes, Lordship, he's here, but we'll be requiring some more time, Lordship.
Who's the other side?
Lordship,
You haven't informed them?
I've looked for them,
The
Lordship.
matter be called out.
Okay, much obliged, Lordship.
Yes.
Supplementary list item number 1.
Please, Your Lordship. Your Lordship, this matter pertains to the bifurcation of Minsang village. Lordship, in the year 1998,
98?
Yes, Lordship. In the year 1998, the village was bifurcated and Lumsuntung locality was carved out of it. And in the year 2003, it was recognized as a full-fledged village.
Lumsuntung?
Yes, Your Lordship.
Okay. Then?
Lordship, being aggrieved by the same, numerous representations were sent to...
You are aggrieved?
Yes, Lordship.
But bifurcation cannot be without your consent if you're a parent village?
Yes, Your Lordship. Your Lordship, if I may take you to annexure 9, which is at page 63.
Yes.
The village was bifurcated on my recommendation, on the recommendation of my predecessor, Mr. S.S. Lingdor, who was purportedly supposed to be the headman at that time in 98. Now, Your Lordship, with this representation, he had sent to the respondent authorities stating that he withdrew his recommendation for bifurcation of the recognized village.
Yes.
As he was not the headman at that present time, at that given point of time.
But by that time, already been bifurcated?
Yes, Your Lordship. Lordship, being aggrieved by the bifurcation, my predecessors preferred a writ petition before the Guwahati High Court, Shillong bench, and provide order dated 27/08/2012. The Honourable High Court was pleased to pass an order directing the respondent authorities to hold a fresh dorbar to ascertain whether the majority of the villagers were in agreement to bifurcate the village. In compliance to that order, a Dorbar was convened, Your Lordship, on 20th 12, 2012. And in that Dorbar, Lordship, if I may take Your Lordship to the minutes of the meeting held at that Dorbar, which is at Annexure 6, page 45. Annexure 6, page 45, Lordship. The translated copy is at page 46.
Yes.
The last paragraph of that of the minutes, Your Lordship. Therefore, on this day, 20th 12, 2012, after much deliberations at the Dorbar, it was unanimously decided that Lom Sentung will not be identified or recognized as a full-fledged village from this day forward. Now, after that Dorbar was convened, Your Lordship, the respondent authorities passed an order dated 16/12/2013,
Yes.
whereupon the order states that it cannot be ascertained whether Section 3 of the 91 Act was adhered to or not. But then the question and the matter of bifurcation will not be disturbed, as the Lom Sentung was already functioning as a full-fledged village since the year 2003.
Okay. Yes.
Thereafter, Lordship, being aggrieved by the order 60/12/2013, the writ petitioner, I preferred many representations before the respondent
Now,
authorities.
2013, from that time, they passed order saying that whatever it is, we still maintain that Lom Sentung is a privilege.
Yes, Lordship.
Then
I present numerous representations to the respondent authorities, asking them to rescind the order and take into considerations that the majority of the villagers, both from the new and the parent village, do not want the bifurcation. And numerous representations and signature campaigns were also sent from the new village to the parent village, stating that they are not content with the administration of the new village and that they wanted to be amalgamated back into the parent village, because most of the they are completely dependent on the parent village as it is right now as well, Your Lordship, on the ground reality.
well, one thing was the same from this is 2013 order. What are you challenging now? This order.
Lordship, because what happened is that there's a breakdown in the administration of the village, because in the year 2023.
That is 2013 now. It's 11 years ago.
Yes, Your Lordship, but we did not sit with our hands behind our backs. We kept on sending numerous representations, Lordship, being aggrieved by that. Then thereafter, Lordship, in the year 2023, the then headman of the new village, Lom Sentung village, sent a representation to me stating that he wants a date to be fixed so that they can finally decide on the boundary of Lom Sentung. Now, Lom Sentung does not have a definite boundary, Lordship, of administration. And in the year 2024, this year itself, Lordship, there was land which was purportedly supposed to be in the administrative jurisdiction of the parent village. But that sale of the land was contested by this new village, stating that it was under the jurisdiction of the new village. Now, that matter could not be resolved, and it was escalated to the office of the Lingdo Arat. And, Your Lordship, that also could not be ascertained, Lordship, because of the confusion which has occurred based on the order of 2013.
Yeah, the thing is that, yes, Mr. Kanta, how do you plan to resolve this?
No, this is, they are hit by latches. Let's forget delay also. Now, way back in 2013, there is a decision made by the EC that it should not be de-recognized. It should
But
remain.
they say that, from what I saw just now, that you don't want to unsettle a settled position.
Yes.
That's all, yes.
It's too late in the day to do anything right now. What is left is bifurcation of certain boundaries. That's the issue that is open. And perhaps the same of Milim will be in a better position to oversee the boundaries, where it should be.
No, but see, the thing is that will never end. If they are not agreeable to the creation of Lom Sentung as a separate village, that means the issue can't be put to rest. There has to be some sort of a media, because it involves people in the villages on the ground. You can't have a acrimonious situation.
That's correct.
And
What does Emilium do? Can he do anything? He can't do anything. In the face of the executive committee order, what can he do?
In fact, status quo ante at this stage will be.
The two questions status quo ante. The question is how to go forward from here. What has happened? Water under the bridge. Now, whatever happened at that point of time, some recommendation was given, that was withdrawn. The
Yes, Lordship.
veracity of that also has not been tested, examined. Now he submits that the village never accepted, nor the new village. And so these issues will
You
rise.
should have
development.
challenged 2013. You could have challenged immediately that they are not agreeable with that. Now, laches is the issue here. Whether Writ Court will condone the delay and laches that has.
Lordship, the ground reality
No, but
is that
how in the village what is happening now?
the ground reality is
Are
that
they exercising separate jurisdictions and functioning as separate villages?
to the
In all aspects. I mean, not only in not only in kind of a nominal kind of situation, but whether they have their own headman and darbar.
They do have their own headman, Lordship, up to that extent, Lordship. But everything else is dependent on the parent village. When it comes to rations, fair price shop, schools, church, everything else is dependent on that, Your Lordship.
Let notice go, Your Lordship. Then we will
We
know.
have to keep that in mind because we don't want a situation as heard Mr. LCM, the counsel with the petitioner. Issue notice. Mr. V. Ganta with West Nongklau.
I'm 1, 2, 3,
Behind
4.
the currency with C. Nongklau. His present accept notice on behalf of respondents number 1,
1, 2, 3, 4.
2, 3, 4.
Mr. L. Korean present accept on
Five.
behalf of number 5.
5, Lordship.
Notice to go to the remaining
6 and 7.
to 6 and 7. Why you meet Deputy Commissioner Party?
Sorry, Lordship.
Why you meet Deputy Commissioner Party?
Lordship, because various governmental schemes have
Who
been.
campaign for the state? MSNG Shilla is present accept on behalf of 8, 9 and 10. Steps were taken on the respondents
6 and 7.
6 and 7 within 3 days. Stop. List after. You just after 3 weeks. Yes.
3 weeks, Lordship.
Much
To the
obliged.
affidavit.
Obliged, Lordship.
Item number 2.
Your Lordship, Mr. S. Thapa is the counsel in this matter. He's in bereavement, Your Lordship. I'm praying that this matter may come up next
Issue
week.
notice. Heard MSBF Karun Lang. Issue notice returnable in 3 weeks. Dr. N. Mozika, Leonard DSEI with so and so. Is present accept notice on behalf of all the respondents who put the notice called for. Just accordingly and so and so.
Highly obliged.
Item number 3.
Yes. Yes.
Lords, we had given the chart to my learned friend along with the copies of the bills and the receipts. Where are the receipts? There's the receipt.
Mr. Pandey, you received a copy of the chart?
Well, I have shared with my friend.
Yes.
Yes, Lord, I have received
What
a copy of the chart.
is your response to that?
What must?
Yes, my lords, as far as the current dues are concerned, my lords, IFC sought instructions. The current dues are, my lords, correctly reflected in the chart. And there is...
Current
my
dues
lords,
how much?
My lords, if your lordships, this chart that I've given your lordships will kindly see. My lords, the consumption is nothing, it's 0. Only the fixed charges, my lords, are coming to 22 lakhs 51,000 and 23 lakhs 26,000. That is for the period, my lords, where there has been no consumption.
This is period is 1 second.
Period is, my
From
lords,
1
1st
month
April,
from 1st of April to 1st of May.
May and 1st
from
of May to 1st of
to
June.
1st of June. You've got fixed charges around 50 lakhs.
My lords.
That's it. Yes?
That's the period when there has been no consumption.
Yes?
Yes, my lords, and they have deducted the delayed payment charge, which, my lords, because the previous amounts are not calculated, that will be excluded. That is correctly excluded, my lords. So, in total, my lords, it is correctly reflected as 22 lakhs and 23 lakhs for the 2 months.
So, apart from these fixed charges for which no LC has been consumed, are there any other outstanding current charges which they are liable to pay?
My lords, I don't have any instructions as far as other charges are concerned.
The bills are here,
because
my lords, that would
this is, my lords, these are the charges, my lords, which are pending, my lords. Your lordships can take it. These are the charges which are pending. My lords, apart from that, my lords,
Only thing is
my
that
lords,
your self-disconnection.
My lords, that is not correct, my lords. That email will bear me out. If your lordships just permit me, I'll just take your lordships to that email. Even the page. Email. That's my paragraph is not happily worded, my lords. I must concede before your lordships. At page 24, if your lordships kindly have a look.
20?
Page 24, my writ petition. My lords have it. This is where my lords in para 8, that paragraph, your lordships will kindly have a look, my lords. This is a reminder to a letter dated 20th of March 2024. Dear sir, we have stopped using electricity from the 21st of March 2024. Hence, please consider our request for not charging fixed charge from so-and-so. So it is basically a case of not consuming, my lords, not a case of disconnection, self-disconnection.
Yes, Mr. Pandey. You maintain that they have to pay the fixed charge. Yes?
If your lordship may permit me, I have prepared a one-page note, my lords, if my friend can hand it over. That will, my lords, help in assisting your lordship in this matter. So, my lords, here the case, my lords, is in respect of the fixed charges.
One thing first, just be clear. Are you acceding to the request for disconnection? Suppose leaving aside the fixed charges, liability of fixed charges?
No, not at all, my lords, and that is the reason why the fixed charges are payable, because there is no disconnection in terms of the Meghalaya Supply Code, and that is why the fixed charges are payable, my lords.
The Act.
So,
Act.
My lords, may just see the section 45(3) of the Electricity Act. is power to recover charges, and it says, subject to the provisions of this section, the prices to be charged by a distribution licensee for the supply of electricity by him in pursuance of section 43 shall be in accordance with the tariffs fixed from time to time and conditions of license. Then, 2 is the charges for electricity supplied by the distribution licensee shall be fixed in accordance with the methods and principles by the State Commission, and published in such manner. And then, 3 is very important. For our purposes, 3 is important. The charges for electricity supplied by a distribution licensee may include a fixed charge in addition to the charge to the actual electricity supply. So, that is obligatory, that a fixed charge has to be levied and they have to pay, Now, in this context, sees sees Regulation 6.
One second. What are you? Sorry, Regulation 6 of the.
Regulation 6 of the Meghalaya Supply Code. I had earlier supplied a copy to your lordship of that regulation, and the relevant regulation, is 6.6.
This is what they wrote.
Yes.
Temporary disconnection. 6.6 is disconnection. First is the temporary disconnection. It says that a consumer shall be required to make a written request. Yes. As per the prescribed format in Annexure 24 of this regulation, of the office to the office of the licensee, if the consumer wishes to get his temporary disconnection in case of no occupancy or renovation for a period up to 6 months. So a written request has to be made. The consumer shall also be liable to pay disconnection and reconnection charges. So that charges are applicable.
What about D? Come to D.
D, yes, my lords. So if all the
how do you reconcile 6.6D with 44 or 45.3A?
My lords, in my humble understanding, my lords, the D will kick in if all the conditions are satisfied and a temporary disconnection has been granted. So finally,
No, see,
what
it hinges on two things also. Now, their resistance to, like, your insistence for outstanding charges is because that matter still seized with the commission, right? With regard to
Yes.
what is the tariff which is to be
Right.
levied upon them, right? So out there they have over
Right.
10 crores, I think, of outstanding dues.
Yes, Lord.
Yeah,
Yes,
so
Lord.
which you say outstanding, which you say they're not liable because they're governed by special tariff. Now that's still to be decided.
Right.
Right, and so we come to the next part now, disconnection. Disconnection, that means that, if you say as per 45.3 they're liable to fixed charges, then fine, they have to pay fixed charges during disconnection period. But 6.6 of the supply code says that no charge will be levied. So how do you reconcile these provisions?
But, no, my
In your
lords,
submission, how do you
because
reconcile it?
No, in my submission, my lords, I reconcile it that 45.3 is an obligation that till the time you have a proper connection, fixed charges will be applicable. But if you make an application to the distribution licensee for temporary disconnection, saying that my premises are under renovation, I please disconnect my electricity, in that circumstance, my lords, there is a window given that the fixed charges won't be leviable, and but what you require is to follow the conditions prescribed by the supply code. Today, my lords, just for a moment forgets that for the other case of special tariff. Whatever be the situation, they made a request for temporary disconnection. That request was not accepted. Then they, on their own, disconnected their electricity supply. So a person who does not follow the regulation is not entitled to any benefit by this honorable court.
When it fall
That
of
is the-
section 138.
And my lords, yes, my lords, this is an offence which has been contemplated by the Electricity Act. Kindly sees, my lords, 138, section 138 of the Electricity Act in this.
This is for injuring a meter.
My lords, just see, kindly permits me, my lords, just. So, my lords, 135 onwards it starts, but 138 is specifically in applicable. 138, my lords, says interference with meters or works of the licensee. And then it says whoever A, unauthorizedly connects any meter, indicator or apparatus with any electricity line through which electricity is supplied by a licensee or disconnects the same from any such electricity line. So here is the case of disconnection, and that is covered by 138 pillars. So it is today a person who is in conflict with the Electricity Act is seeking, my lords, equitable relief from this honorable court. So that is, my lords,
what according to the respondent corporation, was the situation on the ground? Is the line connected? Do you consider it connected? Even if disconnected by themselves, do you consider the line, their connection, live or disconnected?
my lords, it will be live because the fact is that
Once it is live.
because the fact is they have not complied
say, my lords,
with
it's live.
Right.
live for the purposes of billing, my lords, because they have not complied with the regulations for the purposes of disconnection. So how can we contemplate a situation that it has been disconnected? It can be only disconnected in accordance with
So
law.
we'll make it via media. You pay fixed charges for 1 month, you disconnect the line. Mr. Paul,
My lords, they have to
you pay some charges for a month of April. And
my
the
lords,
line
both the months they are liable to pay.
doesn't
They are
matter.
not
We have
anyway-
to balance out the situation.
My
If you
lords,
say
what I would
balance,
suggest,
if you say it's equitable, let me balance the equities.
Well, I'll have to seek instructions.
You pay 1 month, then let them disconnect, and there'll be no fixed
Well,
charges.
only query that fell from your lordships, Millets, whether the line is active or whether 138 would come in. That is borne out from the bill of the respondents, Millets, because they have raised the bill dated the 18th of June 2024, which shows that the line is very much live. It's just a question, Millets, there is electricity in this room, but if I decide to switch off the light, Millets, then I'm not consuming it.
Yes, you don't switch off the light. That is your.
That's my prerogative, my lords, whether I want to run the plant or not. They 138 will not come in. 138 is tampering.
You take a suction. That's the mind of the court. That's all. You pay. Let them pay charges 1 month for April.
Well, what I would suggest that because there are
if they have
10
any other
crore,
issues, they can take it to the consumers forum. With regard
the
to
other
bill.
issues, anyways,
the other
pending
matter.
before the MSCRC.
Yes.
Other issues, my lords, are anyways pending before the learned MSCRC, and it is functioning now.
What is basically happening, my lords, if your lordships just permit me a minute. What is basically happening is, my lords, even in spite of a consensual order passed by this Honorable Court, the insistence on the part of the corporation, my lords, to recover that amount is what has led to this.
No, court's alive to that. We've seen that in spite of the order passed that, all differences will be thrashed out before the regulatory commission. Now, while you ask for disconnection, they've raised the same, that they've raised that issue again.
My lords, what is more alarmingly happening?
Being public revenue, we can't close our eyes also.
My lords, what is more alarmingly happening is, my lords, today your lordships would have noticed that the difference of bill is 10 crores, my lords. 3 months later, when I'll be before your lordships, my lords, that difference would be 15 crores. Now, what is happening is, my lords, on that 10 crores, they are again charging interest. So, every month, my lords, that figure is keeping on growing. And every time they are before your lordships, my lords, they would come and tell your lordships that I'm a defaulter in payment of 15 crores.
Vicious cycle. Vicious electrical cycle.
If I may, my lords, there was this movie of the 60s, Do Bigha Zameen, my lords, where they say that this man takes a loan and there is the interest on the loan and interest. So 3 generations go and the interest is never paid. Forget about the principles. It unfortunately seems, my lords, that MECL has gone on such path.
Unfortunately, Vilas, this is a 200 bigha zameen. This is not a 2 bigha zameen.
So,
yes.
Therefore, my lords, the rate of interest should be higher.
Yes. We'll have it on Monday, but then
your lordships, may I
otherwise
pray,
we relegate it to the
Well, insofar as we are concerned, my lords, we've been paying. Item number 4, my lords, which is the next matter, there was a prayer for load enhancement.
Yes.
It's not a case of disconnection. Again, same letter, my lords, saying that you pay off the earlier dues or else we'll not allow you to.
We are party to the same.
Yes.
Yes, it's item number 4. Yes. So number 1, Mr. K. Paul prays that he allowed the matters heard at some length. Mr. K. Paul is in the council prays that he allowed to obtain instructions from the petitioner just on Monday.
My lords, may I pray for Tuesday, my lords? Monday will have little difficulty.
Tuesday, okay.
My lords, if your lordships kindly have page 22.
Yes.
My lords, may see, this is the letter dated. We had prayed for enhancement of load, my lords, when they say, I am directed to inform the applicant for additional demand of so-and-so, enhancing the contract demand for so-and-so has been examined. In line with clause so-and-so, so-and-so, the application for enhancement of contract demand will not be accepted if the consumer has any arrears to the license. However, the application may be accepted if payment of arrears from the due of this has been stayed by a court of law or by the commission or by an authority of the commission. Whereas in the instant case, it is pertinent to mention the applicant have filed a case against so-and-so, challenging so-and-so, issued by the so-and-so. In this regard, commission has granted stay in favor of the applicant company, restraining corporation from initiating disconnection to the premises. However, there is no stay from the commission towards payment of arrears. As on date, the applicant company has an outstanding of so-and-so. As such, in line with so-and-so, it is agreed to state the load enhancement as requested cannot be sanctioned. Well, this is in the face of the orders passed by this Honorable Court.
Yes.
If I may submit, Milords.
Mr. Pani, yes.
Yes, Milords. Milords, again, this request has to be again seen in the context of the MSCRC supply code. And for this case, Milords, the supply code is even more clear and categorical. Milords, just see 6.4.
My lords, if I may just take your lordships 1 second, my learned friend may also address your lordships on this. Are they denying, my lords, that there is an interim order? They challenge an interim order before your lordships, my lords. By consensus, we decide that that amount is to be frozen. It would be subject to the outcome of the MSCRC case. It is apparent from the language of this letter, my lords, that the case is alive. My lords, in this letter, they forget that there was an order passed on 5th of December 2022, staying, my lords, any additional amount that was to be charged under the new tariff. That was the matter which led to a lot of litigation. We come to a consensus before this Honorable Court and the matter attains finality. Matter admittedly is pending before the MSCRC. and my lords, every request made by the petitioners before the distribution licensee, my lords, we are met with these kind of letters.
Yes, Mr. Pani, what do you have to say?
Yes, my lords.
Yes.
Just sees, my lords, 6.4 of the Meghalaya Supply Code, my lords.
I think we have to compose a small manual. This matter keeps on all these matters. So many of them.
We'll prepare an
keep the code, the
My lords,
electricity code, the supply code.
These electricity matters keep on coming before your lordships. Just ensure these.
There are multiple regulations, my lords. Yes.
Multiple regulation, multiple litigation.
Yes, my lords. Kindly sees, my lords, 6.4.
Yes. Yes.
6.4, my lords, says that procedure for enhancement of contract demand and connected load. Yes. This is the procedure prescribed. One says the applications for enhancement of load shall be submitted to the concerned officer of the licensee in the prescribed form. And then, my lord, 2 lays down the procedure that the licensee shall inspect the premises within 7 days of the application. My lords, may just leave that because that may not be very relevant. Directly comes, my lords, to 3. The application for enhancement of contract demand will not be accepted if the consumer has any arrears to the licensee. However, the application may be accepted if the payment of arrear due from the consumer has been stayed by a court of law or by the commission or an authority appointed by the commission. So the distribution licensee, my lords, is bound to comply with the Meghalaya Supply Code, and it says that there has to be a stay of the outstanding area.
Then?
Now, my lords, though the order passed by your lordship on 15th February 2024 does not state the outstanding areas, my lords. It merely says that all disputes between the parties are open and the learned MSCRC has to decide the matter expeditiously because public revenue is involved in this matter. So, my lords, the distribution licensee cannot go against the regulations which have been framed by the MSCRC. So, in this, my lords, our hands are also tied because if, my lords, in this context sees section 56 of the Electricity Act. of the Electricity Act.
56. Yes.
And this may be relevant for both the connected matters, my lords. 56.
Why?
My lords, 56 is...
Why is it relevant?
My lords, I'll just indicate why it is. My lords, 56.2, my lords, 56 is disconnection of supply, and then 2 is notwithstanding anything contained in any other law for the time being enforced, no sum due from any consumer under this section shall be recoverable after a period of 2 years from the date when such sum became first due, unless the sum has been shown continuously as recoverable as arrear of charges. For the electricity supplied, and the licensee shall not cut off the supply of the electricity. So it is, I am bound to show the outstanding arrears continuously as due. And the regulation says that either they pay off the arrears or there has to be a stay by a court of law on the arrears. So if that condition, my lords, in my humble submission is not satisfied, then the petitioner is not entitled to a load enhancement in terms of the regulations.
So your submissions are arrears have not been stayed by any court of law, and that if you don't maintain,
yes,
if you don't keep on charging the arrears, then will lapse after 2 years. Then you'll be precluded from.
My lords, I have to show that. I have to show, my lords, what has practically happened. Nobody has sought a recovery of the outstanding dues out of the pendency of the matters, but we have to continuously show them as arrears. And the other benefits under the Meghalaya supply.
Because we are faced with not a normal situation where arrears are due and they're asking for enhancement. Now we have in one hand that matter pending, where okay, you say that there are no stay orders operating, but the thing is that they've been relegated there by this court to thrash out all differences with regard to special tariff. Correct? Now special tariff or the normal tariff, now your arrears are as per the normal tariff. Correct?
Yes,
as per normal tariff chargeable. Fine. Now, how do you address situation then? When if they need enhancement, at the same time, you're bound by the provisions which says that you have to keep on, giving these notices for satisfaction of the arrear bills. At the same time, they also, they need enhancement. How do you address it then? You're interested in your interest also that they should consume electricity. How will you gain revenue then?
Milods, in this situation, my humble submission is, Milods, that as far as the arrears are concerned, none of the parties can take benefit of the situation. Now, today they are trying to say that the arrears do not exist.
Take benefit. It's just that situation as it stands today. That's what it is.
These submissions are being made in the face of 3 orders, Milods.
Yeah, no, Mr. Paul. We understand. No. It's not an empty, arguments that empty or whatever claims they made. The thing is that whether it's undisputed that the matters are pending for special tariff and normal tariff, and then these people are involved. These companies are involved in that matter. Now they have other, side issues which have arisen here: disconnection, enhancement. How does the corporation address these issues?
They can seek a load enhancement without payment of the arrears only in one situation, if there is a stay granted by the court of law.
I must interject, Manoj. If I may just ask this question to myself, Manoj. 3 orders I ask myself, Manoj. 5/12/2022, whether it has been interfered by any honorable court, no, Manoj. You take the challenge right up till the Supreme Court. Supreme Court rejects your application, my lords. Matter is sent back to be decided.
MOU.
Yes, my lords.
Yes.
There is a specific stay order, repeatedly challenged before this honorable court, my lords. Matter taken to the division bench, taken to the honorable Supreme Court by the corporation, rejected in all these forums. Matter goes back before the MACRC, and then, my lords, somebody is coming before your lordships and saying that there are no interim orders. I would pray, my lords, let MACL file an affidavit before this honorable court.
Have you filed affidavit here?
They have not filed any affidavit, my lords. May I pray, my lords, may direct them to file a specific affidavit that there is no interim orders operating, because that would be perjury.
My lords, may kindly see the writ petition. There is no averment at all that there is stay order operating.
My lords, I don't need to.
So see, now
I will just simply, my lords, your lordships may kindly have a look at page 27 of this writ petition. That's the order passed by this honorable court. My lords, you come before you come on challenge of an interim order passed by the commission before this honorable court, my lords. You don't get any relief. We decide on consensus, my lords. Let the matter go back to MACRC. Let MACRC decide the matter. Till then, the matter is frozen. And then, my lords, to have the audacity, if I may say, to come and say that there is no interim orders, I would pray, let them file an affidavit. I would have no case then.
Yes.
First of all,
let them file an affidavit, my lords. There is no interim order operating.
There's no need to file an affidavit. I think
there is
we'll do one thing.
I need not file an affidavit.
We'll do one thing. If you're able to file an affidavit or state instruction, yes, I'll court will pass orders.
Milords may pass orders, but prior to passing order, Milords may permit me to place one authority, Milords, on this issue. My friend is carrying judgment of the Honorable Supreme Court of CC versus Dunlop. Milords, kindly allow me to place.
Well, where is the question of public revenue?
This is a public revenue. And
my lords, what the MECL is forgetting is they are trying to deal with it as a private limited company. Here for the purposes of making money. The Electricity Act does not contemplate the distribution licensee to be a money churning unit. It is an entity of the government. That's why it is a corporation. It is not a
losing unit. That's a money churning unit. Yes.
This is a 226
well, therefore, coming before your lordships with these kind of pleas.
Yes.
For a state, Milords, kindly sees, Milords, CC versus Dunlop, Milords. This judgment, Milords, categorically decides this issue and what will happen in these kind of situations. Milords, kindly sees paragraph 2.
I think your associate is not the correct judgment. There's no Dunlop.
This is a 1985, my lords.
Khonde
1985
Distilleries
one
and
SC.
Surya Developers, my lords. Dunlop.
What relevance will this have? This Surya
I
developers?
do not have the copy right now. I'll supply to the court master.
My lord, if your lordship permits me, then I can read the relevant paragraph, or my lords may fix it on some other date. I'll ensure
Your
that the
lordships have
copy
fixed
is-
them at
Flash it out. Yes, otherwise you come ready. Or
my lords, I would only pray, my lords, let them come with an affidavit.
Otherwise, you file an affidavit, otherwise board will pass orders.
Well, let's let
Enough.
them file an affidavit because it will make things easier for us.
My lord, affidavit
My
has
lord,
been filed.
the
We have already
first
filed our
the
affidavit.
first
And
thing
the
has
second
to be an
one-
averment for
On
me to file
disconnection,
an
on
affidavit.
disconnection,
My lord,
there's
in
not
both
much,
the matters, we
there's
have
no
already filed an
controversy.
affidavit.
But in this matter,
saying
not
this.
because you say that you're bound by statute, so it's different.
Yes, my lords.
Let's both is matter. Let's the matter together with so and so.
Tuesday, my lords.
Item number 5.
Affidavits. One corporation may file affidavit in the meanwhile. Yes.
My lord, this will be an additional affidavit, my lord.
The second matter.
My lord, in this matter, we have already filed an affidavit.
You file an affidavit.
It will be an additional affidavit, my lord.
Otherwise, yes.
My lords, may permit me to file a short rejoinder and I'll bring all the orders passed by your lordships on record.
Just here, you can bring this. Petition also permitted to file
Obliged.
any additional materials if required.
That's obliged.
Yes. Where's Mr. Chakravarti?
Lordship is having some personal difficulties.
So you're agreeable to this?
My lords,
justice
I
by
have to seek.
R.Y. Ganu.
My lords, I have to seek instructions. I was just informed yesterday.
Why you've never heard of him? Is that the only apprehension you have?
Not apprehension, my lords. I have to just seek instructions, my lords. Since it's an arbitration issue, my lords,
But the thing is that as per the agreement, they are at liberty to appoint the arbitrator.
well, it's that in view of the 2003 amendment, that may not be available to them anymore. I'm sorry, 2006 amendment, that will not be available to them. Because that talks about an in-house arbitrator.
And jurisdiction, you have no problem, Bombay.
Well, we are more interested in getting the matter disposed of, my lords. Because what has happened here is, my lords, we took a loan, we've repaid the entire amount. After we've repaid the entire amount, my lords, now they say that, oh, you played a fraud on us and you have not paid us this much, this much.
Okay, Tuesday.
By Tuesday, my lords. My lords, may also grant me liberty, my lords, because I had also furnished, originally, we had given a list of few persons whom we thought, my lords, could be nominated as arbitrators. We'll place it before your lordships and for your lordships' kind consideration. Obliged.
Daily list item number 1.
Madam, miscase number 7 may kindly be taken up because that is the miscase which I am.
I pray that this matter may be taken up next week, my lord, because this will require some extensive hearing.
It's your day, Mr. Pandey, today. You're having your day in court, so make full use of it.
That's what we had submitted before
You
Lordship.
file an application then.
What we had submitted before Lordships was that
Yes,
this
my
is
lord,
also
file an
covered by the 2 judgments delivered by your Lordships in the 2 other matters. The last order says that my learned friend at my lord said, submitted before your Lordships, that it may not cover.
It's not covered. No.
So do that.
He's not ready with the matter today. Yes, you put an application for adjournment, yes.
Yes, please. Obliged, my lord.
Item number 3.
Point number 3.
Please, your lordships. My lords, I appear for the petitioner, your lordships. My lords, in this matter, my lords, an affidavit has been filed by the respondent, your lordships. My lords, they admit to the arbitration. In fact, after the filing of this petition, there is an internal letter, my lords, wherein they have themselves written to the department saying that, see, that you did not appoint the arbitrator, so the contractor has gone ahead and filed a petition, my lords, in court.
This is on the 11.
In my affidavit, my lord, in para 31, I said.
This is under section 11, my lord, for the runway.
Right. So what internal letter?
My lord,
Lordships, it is at page 22 of their affidavit of the response, my lords. Page 21 and 22. Lordships, where, my lords, internally the chief engineer has written to my lords, the ENC recommending the names for the arbitrator.
Where is that?
Page 22
Lordships,
of my affidavit.
Page 22.
Page, my lord, 22,
Okay, because after
6th June 2024.
Yes. Yes. Vidyut Kumar
Lordships,
Pradhan.
if I only may make a suggestion,
Yes.
my lords, there are 4 names. Lordships, I may only make a suggestion. My lords, may appoint Mr. Saurabh Mathur, my lords, to cut short the controversy, my lords, because since he is a retired officer of the department itself, and it's a specialized contract, and there are technical claims. So, my lords, may appoint Mr. Saurabh Mathur, my lords, from this list.
In fact, in para 31, we've said so. So, the affidavit.
We'll pass orders then. Yes.
Saurabh Mathur.
Right.
It is also in the.
Yes. Anything else? Yes.
Item number 4.
No, that's it, your lordships, made. Grateful, my lords.
Please, your lordship. Your lordship, there appear.
Apologies, my lord.
You corrected then.
Yes,
Mr. Film Nobody submits that in the objection filed to the Mrs. application of the petitioner, some defects have corrected which needs to be corrected. He prays once allowed, on which time to correct the same for registry. For registry or to file a fresh one?
Registry, my lord.
For registry, yes.
Deeply.
Item number 5.
May I please, your lordship? This matter is supposed to be argued by Mr. Khan, senior advocate Mr. Khan, my lord. Due to some personal difficulty, my lord. Matter may be
Why? What's the difference between you and Mr. Khan?
My lord.
What's the difference between you and Mr. Khan?
My lord.
Consider yourself incompetent?
No, my lord. Sir, my senior will argue this matter, my lord.
Mr. Nandi has come from far away.
Yes, my lord.
You pay his taxi fare or car fare, lunch and everything.
My lord, first time we are seeking time, my lord.
The last occasion also this similar prayer was made.
My lord, this matter fix it on maybe fix it for hearing in the hearing list, my lord. Next date we will do the hearing.
Interim order, who's enjoying? You're enjoying.
We are enjoying.
Then?
Yes, my lord.
Will you vacate interim order?
No, my lord. This matter has to decide, my lord. Only on we come before this court on to consider on 2 points, my lord. Whether the petition filed in the under 144, 145 before that court was having jurisdiction or not. Second is whether the time period in spending the in those courts, my lord, can be computed under Section 14 of the Limitation Act or not, my lord. Only these two issue needs to consider, my lord. Only these two issue, my lord.
My lord,
What to do?
if the very revision petition is perused that they have filed under 227 of the Constitution of India, the ground number 3 and 4, they themselves have stated that evidence is to be adduced. When these are matter of facts and evidence is to be adduced, in view of these facts, then where this question for framing the preliminary issue on law comes up, and where the mistake has been, there is no mistake committed by the.
Mr. Nandi, he's handicapped because I think engaged a senior in this case. So you take a short date.
Yes, ma'am.
And we'll dispose it on next date.
Yes, ma'am.
And even if he's not present, you will conduct the matter.
My lord, yes, my lord. No, my senior will conduct the hearing, my lord, due to some difficulty today, my lord.
Mr. S.K. Hassan today has prayed that some accommodation be given due to the absence of the senior arguing counsel.
My lord, in that case, date may be fixed on 21st of August.
Yes. Mr. Nandi has raised objections in interest of justice. The matter stands adjourned to 21st August. It is made clear next date no further adjournments.
My lord, interim order may continue, my lord. Yes, ma'am.
Shall be taken, and Ms. S.K. Hassan undertakes to argue the matter in case the city council is not available.
My lord.
Yes,
My lord,
this accordingly.
in case interim order may be continued.
Interim order passes continue till the next date. Yes.
Item number 6.
Highly obliged.
Deeply obliged.
Yes, well, we joined the affidavit. You don't want to file anymore?
Lordship, I prefer to pray for 2 weeks' time, Lordship.
How many times you prayed?
This is second time, Lordship.
Second time?
The counter affidavit is in voluminous, Lordship.
2 weeks further time. Otherwise, we'll dispose the matter. Yes.
7.
Lordship. May I please, Your Lordship?
We are appearing for them also?
Yes, Your Lordship.
Very
but we'll
good.
file the Vaklanama on the next day, Your Lordship.
MSN Raji submits that Mr. S, who will appear? Day or Deb or you?
SD.
SD. Submits SD will be has just top in. MS Ranjit has entered appeal on behalf of respondent 3 and 4, and as such the service complete. She prays funds allowed how much time? 3 weeks time to file affidavit. Yes, sir. No effort from your side.
After them, Lordship.
Yes.
Item 8.
Lordship, they have sought time on 5 occasions for filing affidavit.
No, Your Lordship. For us, this is the third time, Your Lordship. We have asked time.
So far, the district council is concerned. In fact, they were only required to produce the record. But private respondent, Your Lordship, this is the 5th time they are.
5th time in taking.
And they are in possession of the property and
enjoying it.
Enjoying it.
Yes.
He was supposed to come and sign yesterday, Your Lordship.
So how much cost he'll pay for enjoying the property?
And they are taking the rent, etc. Everything.
Last questioning, Your Lordship.
They'll file it by tomorrow, by Monday.
He was supposed to sign yesterday, Your Lordship. However, he didn't come yesterday, Your Lordship.
Give them one more chance, Mini. It's okay.
Give them, Your Lordship. By next week they will file.
Numerous points have been granted for filing affidavit on behalf of sponsors 3 and 4 are the same. The said affidavit is still not on board. Mr. Pasanthi submits that the same has occurred due to unavoidable reasons. In the interest of justice, final opportunity is granted.
Even
it should be on file within 1 week.
Your Lordship, even us also, Your Lordship will be filing affidavit.
Yes.
After 1 week, Lordship.
2 weeks, Your Lordship. 2 weeks, Your Lordship.
Why?
Because we need some clarification with the affidavit, Your Lordship.
Becoming a shop for bargaining.
No, Your Lordship. 2 weeks, Lordship.
Okay, 2 weeks.
9.
Please, Your Lordship. Lordship, I'm praying for some time, Your Lordship. We've sent the affidavit. Your Lordship, by next week, we'll be able to file, Your
My
Lordship.
Lord, I represent 5, 6, and 7. My Lord, I'm praying that if Lordship may kindly permit one affidavit to be filed for these 3 respondents. Because, my Lord,
Yes.
they are same, they are VEC elected members.
MS Eilingwap 1 to 4 and Ms. R. Kolni for 5 to 7. Please said we will out further 2 weeks time we will file affidavit. Prayers granted. Or give them 3 weeks.
2 weeks, Your Lordship.
3 weeks.
2 weeks, Your Lordship. Obliged, Lordship.
10.
Lordship, yesterday we have received the affidavit filed by the state respondent.
We filed, Your Lordship.
We may be allowed 2 weeks' time to file our rejoinder.
If I rejoinder,
Yes.
necessary, not necessary. Yes. As prayed, 2 weeks time is allowed for rejoinder affidavit by the petitioner.
Obliged, Lordship.
11.
May I please, Your
Lordship, we
Lordship.
filed the affidavit, my lord.
We have just received the copy, Your Lordship. I'm even yet to go through, Your Lordship.
You have not gone through as yet.
We just received the copy.
Akhrashin submits that they have just received the court affidavit filed by the respondents. You will file rejoinder. She prays you will have 2 weeks time to file rejoinder if necessary.
Much obliged, Lordship.
Much obliged.
12.
Still awaiting instructions. My Lord, we are praying for some time, my Lord, for the counter. We have for respondent number 1.
Yes,
and 2,
MS
my
and
Lord.
Raji. Yes. What about number 5?
I have
Served.
my service report, Lordship.
5?
5 is School Managing Committee, Lordship.
Mr. Aring.
Yes,
Alan
Lordship.
Aring. Have you filed a source affidavit?
Yes, Lordship.
Already
Yes,
filed?
Lordship. Yes, Lordship. Just yesterday.
Take it on. Fine. Strike out. Service an affidavit indicating service in respect of number 5 we filed a petition. As such, service is complete all the respondents. Mr. Kibiwat Raji 1 to 4 and MS Andraji for 6 and 7. Who's appearing for 5? No one appearing. Praise for not for a 2 weeks time for affidavit. Just a matter for 2 weeks for affidavits, but it's said respondent for appearance of respondent number 5. Yes.
13.
Obliged, Lordship.
My Lord, the
Where's Mr.
respondents are
Shulai?
My Lord, here on one last occasion, the previous occasion, my Lord, we have make a prayer that we have make a submission that documents have been furnished, and Lordship is directed if that can be filed to an affidavit. My Lord, now I'm making a prayer if Lordship may kindly permit us to file a proper affidavit, because my Lord, what have happened here is that there is also PIL pending before this honourable court.
PIL?
My Lord, yes, a PIL in which the petitioner he is
You
a
file a
respondent.
PIL also?
No, my Lord, he is a respondent in the PIL, my Lord. So there also, my Lord, similar prayers for furnishing of documents have been made, and time and again state respondents have filed an affidavit or report in which he has been furnished. There's a disciplinary proceeding also pending with. There also we have already furnished. Same prayers being made in the writ petition also, my Lord. So there will be 2 parallel, like, my Lord, documents being furnished to him for the same thing.
You file the affidavit
My Lord,
first
I'll be
indicating
My
that you
Lord.
filed, you served the document, then we can close
Yes,
it.
my Lord. I'm praying
Why
that
not close
if
it now?
No, my Lord. Let them file the
You're not
affidavit
been
first.
served.
No, my Lord. Let
I
them file the
would like
affidavit
to
first,
file
my
an
Lord.
affidavit in opposition, my Lord.
Yes. MS Arconi submits that besides filing affidavit indicating the fact that the required materials have been served on the writ petitioner, she may be allowed also to file a detailed affidavit in opposition.
My Lord.
Prayers allowed this after 3 weeks. Yes.
Obliged, my Lord.
14.
Hearing.
Please, Lordship. Lordship, this matter, Lordship, we have taken steps in the last occasion, Lordship, with respect to respondent 1 and 2. Lordship. We're still awaiting status report, Lordship.
Mr. Titakhar submits that the service report and respondent 1 and 2 still awaited. Yes?
My Lord, I represent the state respondent.
3, 4, 5, yes.
My Lord, I believe we are still waiting for instruction in this matter.
Yes, with regard to response 3, 4, 5, MS Arconi prays that she will allow for the 2 weeks time to obtain instructions and file affidavit. This after 2 weeks for service report on
Instruction, my lord.
respondents number 1 and 2.
1 and 2.
And for affidavit by the respondents 3, 4 and 5.
Deeply obliged.
Hearing, item 20.
Yes.
Lordship, I pray if this matter could be taken up some other day, Judge.
Who's for the...
A.S. Pandey was here since morning, Your Lordship.
What's the matter about?
Your Lordship, it's pertaining to the regularization of the service of the petitioner.
And the request for petitioner this matter after 1 week, please.
Much obliged.
21.
Your Lordship, this is a revision, civil revision petition.
Where's the petitioner? Nobody will have the petitioner. There's no representation on behalf of the petitioner. Stop Mr. So-and-so and Ms. So-and-so present behalf of the respondent. Stop. In the interest of justice, matter stands adjourned after 2 weeks. Yes.
22.
We've received the rejoinder, Your Lordship. Matters fixed
Rejoinder
for
now
hearing.
fixed for hearing today.
Yes, it's fixed for hearing.
Yes. MSD Cruz. You start, yes.
Wait, please, Your Lordship. Lordship, I'm seeking for some accommodation in this
Too
matter.
much. You first adjourn first round in the morning, second round is like semi-finals and finals for adjournment.
Lordship, next week, Lordship.
Actually, this case is barred by res judicata, Your Lordship. If Your Lordship sees your order, which was passed
You ready? You have the file
in
with
the
you?
first
Lordship.
round of litigation, Your Lordship was pleased to decide it.
Where's the
and
order? Any affidavit? The joinders of the file.
Yes, yes, Lordship. It's been filed.
Where's the early order of this court?
Have they filed one?
No.
They have not filed this. This one, Your Lordship, at page 30
Of your?
of their petition, Your Lordship, of their petition.
You prepare it next date, you argue it.
Lordship.
We're not going to argue and we're not going to adjourn just because the counsel is not present. I don't say.
That's the last item.
Then you all go for blood donation then.
You can.
It's not necessary. It's not necessary for wedding process the road, your land.
Lordship, we're not taking over their land.
Lordship, but the stakeholders were not informed. We when
What
all
do
the
you mean
proceedings happened.
stakeholders? Landowners or stakeholders?
The landowners, Lordship, who have interest in the matter, whose interests would actually be violated, Lordship, if the motorable road had to come into being, Lordship.
In the first round of litigation, Your Lordship, these people were brought in and there was a joint inspection where they all agreed that there
Same
was...
petitioner,
that,
Veronica.
yes, where there is no need for acquiring any land of the landowners. So again, they have come with the same petition, Your Lordship.
You keep that in mind next date because you're arguing the matter.
We are not taking over the land, Your Lordship. So the question of giving them notice and land, which was
That's the
done
request.
earlier.
So and so, Just a matter of 2 weeks. It will be submitted by letter EAG that the matter is covered by LA judgment of this court. The Elect Council petition to address this contention on the next date.
Lordship.
Yes.
Wait.